So the last arguments have been filed in the New York concealed carry permit case that is up for Supreme Court review. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, petitioners New York State Rifle and Pistol Association have filed their reply brief in the Supreme Court concealed carry permit case, New York State Rifle and Pistol Association v. Bruen, which will have oral arguments before the Supreme Court on November 3rd. This is a case we are all very much anticipating and will have huge implications for the Second Amendment nationwide. This reply that was filed is very significant because it is the last significant filing that will happen before the Supreme Court actually hears those oral arguments. This brief is in response to the arguments put forward by the state of New York in their most recent brief. In that brief, the state of New York argued primarily that text, history, and tradition support the state of New York's carry permit scheme. Now, if you're not aware of what's going on in this case is a challenge to the state of New York's concealed carry permit requirements. The state requires a person to provide proper cause to be issued a permit to carry concealed. The issue is that the state does not consider self-defense as a proper cause, and therefore on that justification alone, people have their permits denied. Essentially, a person has to distinguish themselves from the average person to be granted a permit to carry concealed. Now let's take a look at the reply brief filed by the petitioners here, New York State Rifle and Pistol Association. In that reply, petitioners have made two main arguments. First, they argue that text, history, and tradition confirm that the Second Amendment guarantees a right to carry handguns outside the home for self-defense. And second, they argue that New York's restrictive carry regime violates the Second Amendment. So pretty straightforward arguments, but let's take a look at these. In opening their brief, the petitioners state, the Second Amendment protects the right of the people to keep and to bear arms. Both the text and wealth of historical authority from both sides of the Atlantic confirm that the Constitution enshrines not just a homebound right to keep and bear arms, but a right to bear them outside the home, where the need for self-defense is acute. They go on to state that, indeed, the historical record is so overwhelming that the state no longer disputes that the Second Amendment protects the right to carry handguns outside the home for self-defense. While the state treats that concession as a non-event, it contradicts its earlier arguments and fatally undermines the reasoning of the decision the state seeks to preserve. The state now retreats to the equally indefensible claims that the right vanishes in populous areas and extends only to those with a non-speculative need to exercise it. So that language and that point is very important. The state of New York has essentially shifted their arguments from claiming there is no right to carry a firearm out in public for self-defense to now conceding that there is that right under the Second Amendment. However, they now argue despite all that, people only have a right to carry in public if the area is not highly populated, and also you can carry for self-defense, but your rationale of self-defense has to be more than just speculative or a hypothetical need. Instead, they argue for a more evidence-based need, i.e., you've actually already been attacked or suffered some sort of harm. To support this position in their brief, the state manipulated English history and early American history, which the petitioners here in their brief and their reply brief actually have to correct. First, the petitioners have to talk about the Northampton-style laws that were mentioned. The state begins by trying to reconceptualize Northampton-style laws as virtually complete bans on carrying firearms anywhere outside the unsettled frontier. But that claim is squarely refuted by text, history, and tradition. Indeed, across centuries of history, pre- and post-dating the Second Amendment, the state cannot identify a single case in which Northampton or its progeny was successfully invoked to prosecute someone for the bare act of carrying a common firearm in public for self-defense. Not one. Petitioners go on to say that that is not unsurprising, since the King's Bench authoritatively interpreted Northampton to prohibit only going armed to terrify the king's subjects, just before the English Bill of Rights was adopted. Petitioners in this section of their brief then have to also go on to point to the fact that it was determined that ill intent was required under these style of laws as well. That ill intent is not met by merely carrying a common weapon in populated areas. Instead, something greater was always required. Now, after this discussion, they then state, despite all that, the really important question is how the right to keep and bear arms were understood in early American history, not English history. They go on to point that all early American authorities on that subject explained that wearing arms could be prohibited only if the arms were dangerous and unusual. Also, early American cases discussed in Heller, which is the Supreme Court landmark case that we have, likewise confirm that the founding generation understood Northampton to prohibit only the carrying of a weapon of death to terrify and alarm, and in such a manner as naturally will terrify and alarm a peaceful people. Now, in this section of the brief, the plaintiffs, New York State Rifle and Pistol Association, have to go through the various citations put forward by the state of New York to support New York's position that early American history allows these types of restrictions. However, in almost all of New York's citations in their brief, they cut out the words like to the terror or offensively, mainly because those citations that they include only work for them if they cut out those aspects of the law. Because the true citations, those references pointed to the fact that carrying in public was only limited in those rare instances where someone did it with the intent to cause fear, terror, or did it to engage in actual criminal conduct. Those laws did not apply to carrying common arms for self-defense in public, which is exactly the law New York has implemented and has been challenged here in this case. In the last argument section of their brief, petitioners argue that the New York law outright violates the Second Amendment. They state the Constitution creates a baseline that the people have a right to keep and bear arms, because that's what the Second Amendment says. That is the text of the Second Amendment. They want to say that the state cannot flip that script by presumptively denying them their right to bear arms unless and until they can show a special need to exercise a right guaranteed to all. The state cannot start with a proposition that ordinary law-abiding citizens may not carry handguns. The Second Amendment itself confers a right, not a privilege, to be extended by the states. Thus, the Sullivan Law starts on the wrong and unconstitutional foot by beginning with the presumption that New Yorkers may not carry handguns for self-defense. They go on to state that things only go downhill from there. The state's refusal to grant petitioners licenses to carry handguns for self-defense precisely because they are ordinary members of the public, not some especially worthy subset, is fundamentally incompatible with the notion that the Second Amendment secures a right to bear arms for self-defense to the people, a phrase that Heller explained unambiguously refers to all members of the political community, not an unspecified subset. They then close out the reply by saying the court should strike down this law using heightened scrutiny, which the state of New York tries to avoid by advocating for this weird type of intermediate scrutiny where they believe courts should just defer to their legislative actions if the law they pass is substantially related to their interests. So we will likely see a lot of these points brought up during the oral arguments. That's why these briefs are really important, and they also give some insight into the issues that will be argued and that we will hear pop up. Now, like I mentioned, oral arguments will happen in this case on November 3rd. And if you're interested in listening along with me, let me know. I've mentioned a few times that I'd be interested in doing a live stream, so let me know in the comment section if you guys are interested in that. Also, if you like this video and like support this channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos, in this type of two-way news, and then it helps push it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos, impacting this channel, and helping this information get out to more people. So thank you so much for doing that. If you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm. And also, if you're a new subscriber, go ahead and comment down below that you're a new subscriber, and I'll make sure I comment back to you. We are reaching 200,000 subscribers, and thank you guys so much for supporting. So, and also, if you're kind of a lurker and you haven't subscribed yet, but you've watched a lot of these videos, please consider subscribing. I would really appreciate that. And then also, the more subscribers I have, the more people that get this information, the more people that become aware of this channel and the type of videos and news that I do. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will maintain by armed scholars.